Hello, and welcome to Ipse Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guests are Camilla Hrdy, Associate Professor of Law at the University of Akron School of Law, and Mark A. Lemley, William H. Newcomb Professor of Law at Stanford Law School and Director of the Stanford Program in Law, Science, and Technology. We will discuss their article, Abandoning Trade Secrets, which will be published in the Stanford Law Review. So welcome to the show to both of you. I believe you're both repeat guests.
Yep.
Yeah, that's right.
So thanks both of you for coming on. This was a really fun and interesting paper, especially for someone who teaches intellectual property, including trade secrets, but honestly I have not really focused much on trade secrets in the past. And this really got me thinking about them in an interesting and provocative way. But for listeners who may know even less about trade secret law than I do, I wonder if you could just say a little something about what a trade secret is. Like, in other words, what kind of information is protected by trade secret law, and what kind of protection does the law provide?
Great. So I'll take that one. So trade secrets are protected under both state and now federal law. And basically, to have a protectable trade secret, the claimant has to show that they have information that derives independent economic value from being kept secret. And that's the basic definition. We get that at the state and the federal level. I should also add that the sort of most common trade secret case you will see is a company trying to protect its trade secrets against its own employees. And so those employees are deemed to be under a duty of confidentiality with respect to the trade secrets they receive on the job. And if they leave to work for a competitor or to do a startup, they can potentially get sued for taking the company's trade secrets.
The one thing I'll add is, just because it may be counterintuitive to people who aren't IP lawyers, is that the definition of things that can constitute a trade secret is extraordinarily broad. The statute talks about information. And while we think of trade secrets as a secret formula or computer code or something technical, it doesn't have to be. A lot of trade secret cases are over things like customer lists or business plans, or even something like a recipe. There are even cases in which religious scriptures have been asserted as the basis of a trade secret.
Well, so what happens if a company or an information owner, I guess, asserts a trade secret claim? Like, what kind of protection do they actually get? What happens if they're successful, or I guess if they're not successful?
So if they're successful, the key is going to be, as with all IP regimes, the injunction, right? So they're going to get, ideally, if things work out best for them, they will get an injunction to stop the employee from, or whoever the defendant is, from using or disclosing the trade secrets. Or in some cases, they can even get what's sometimes called an activity injunction that actually will stop the employee from going and, say, working at a new company. Sometimes they can get that. And of course, there's also various damages available.
Well, so, I mean, in general, my impression was always people tended to analogize trade secret protection to patent protection, in the sense that they kind of both have a kind of invention discovery oriented sort of feel to them. But in the paper, you suggest that might not be the best analogy. And I wonder if you might kind of tease that out a little bit. Like, why do people tend to run with that analogy? And why do you think that it might be better to use alternative analogies to understand how trade secret law works?
I think we have the person to answer that, since his article was arguably partly responsible, along with a Supreme Court decision, for the analogy of trade secrets to patents. So I think I'll toss that one to Mark.
Well, I think there's a lot of confusion about why it is we protect trade secrets. As a theoretical matter, you can think of this as a species of tort law. You've done something wrong, taking my information through improper means, taking my information in violation of a breach of your duty of confidentiality. You can think of many of them as contract cases. You could talk about them as property cases. I mean, I think the best way to think about it is as a form of intellectual property. We are creating a legal right over and above what tort law or contract law or property law would give you in some respects, in order to encourage the development and deployment of new ideas and new information. That to me is the essence of an intellectual property right.
Mm, Well, but so why the typical analogy to patents then, and why might that not always be the best analogy?
So I guess I'll add. So Ryan, I love your question because I think that's really apt. That the reality is there's a huge universe, as Mark was saying before, of information that's protected as a trade secret, not least of which is a customer list, right? So why do we think of trade secrets as a one-to-one sort of choice between patents and trade secrets? And there's really a couple of reasons. I think one is that just as a practical matter, they did start to become very important alternative ways to protect technology or prototypes and the like, aside patents. I think another reason, really, too, is the way that trade secret law developed at the state level. And so, really, the biggest trade secret case that we have from the Supreme Court is Kiwani versus Becron. What's the issue there? Well, the issue is, does federal patent law preempt state trade secret law? So right there, we get this setup of these two regimes as a choice, because the concern, of course, is that trade secret regimes will encourage people to keep things secret, whereas patent encourages disclosure. And so the Supreme Court literally goes through and it's like, yeah, there's three varieties of trade secrets. There's patentable trade secrets, there's potentially patentable trade secrets, and then there's unpatentable trade secrets. And so it's kind of this fiction that trade secrets and patents are really one-to-one. And then, of course, Mark comes along with his article, which, and I don't think I'm understating the influence of the IP, surprising virtues of treating IP as trade secrets, at least within the academic field. And the argument there, of course, and Mark can say it better, is sort of that if we think of trade secrets as IP that only can be protected if you can keep them secret effectively, then it sets up this channeling between patents for subject matter that you cannot keep secret, it's self-disclosing, and trade secrets where it's more efficient to do it that way. But back to your question, Brian, I think the universe is much larger. And I'm hoping that that's something that this paper can start to chip away at, is the fact that trade secret law really does stem from unfair competition law. And as Mark and Mark McKenna have shown in a lot of their work, there's a lot of similar themes in non-patent areas.
So the one thing I'll just note there, I mean, I think one of the reasons you do see it in terms of a trade-off is where we are talking about the kinds of technical information that are potentially the subject of patent, there is a choice to be made. So if you want to patent your information, you can't keep it as a trade secret any longer. And so there are various points at which people have to make a choice as to certain kinds of information. But I think what Camilla is saying is in part that a lot of the work that trade secret law is doing isn't with patentable or potentially patentable technology. It's with a bunch of the other pieces of information, and in particular, how those pieces of information regulate the employment relationship in ways that maybe people haven't really focused on.
Well, so one of the things I thought was really interesting, kind of in the initial framing of the paper, was this way that you pointed to unfair competition law as being kind of foundational in the kind of creation of the concept of trade secret, and then suggesting that implied a kind of potential analogy to trademark law rather than to patent law, as people commonly sort of make that patent law analogy in trade secrets, which, was a little surprising to me, because normally we think of trademarks as being very public, or definitionally public, and trade secrets as being definitionally private. And yet you do point to some really interesting structural similarities. I wonder if you could identify some of those and talk a little bit about why you think that, at least in some contexts, might be a more helpful analogy.
So I guess I can just start. I think of these topics often very historically. So I'll just tell you a bit of the history that I sort of was looking at that led me to this conclusion of an analogy. So first off, I mean, well, we can just look at the names, right? Trade secrets, trademarks. But I was looking at, as I was teaching trademark law, the old Supreme Court case law, like Rick Tanis, and of course the trademark cases, where the Supreme Court keeps saying trademarks, as a species of trademarks, to the extent that they're a species of unfair competition law, they don't establish a right except as appurtenant, except as connected to an established business or trade in which the mark is employed. And I noticed that those cases were not necessarily limiting these ideas to trademark infringement. They were talking about the broader landscape of unfair competition. And then as I started to delve more, you look at some of these earlier treatises, for example, NIMS, the Law of Unfair Competition and Trademarks. The treatise has a chapter on goodwill, trade secrets, defamation of competitors and their goods. So it's clear to me that historically the two were seen as, palming off palming off your goods as somebody else's, and taking another's trade secrets and competing with them using their trade secrets were both seen as acts of unfair competition that the common law very much cared about. So that's one thing. And I do think this point about no rights gross is exceptionally important. That the patent analogy sets up this idea that we have kind of an open-ended right in information like you have in a patent, right? But then when you start to think about it, you're like, well, wait a second. The trade secret hasn't been vetted. It's not deemed to be novel and non-obvious. Oh, and also, you haven't disclosed a darn thing. You're keeping it secret. So what are you giving to the public in exchange for that right? And I started to think more and more about it. And then, of course, you think the fact that the trade secrets used to have a use requirement, and then things really take off. And you see, in fact, again, historically, but we argue still today via independent economic value, trade secrets, like trademarks, had to be used to be protected. So that's, I think, where things come in is this idea of no use, no right. But of course, we need to get more nuance there, because part of our argument is that it's not just about use; it's something much more important, deriving economic value from the information.
So there's one additional commonality that's worth noting, because I think it ends up kind of driving where we go with our suggestion at the end. And that is that both trade secrets and trademarks, unlike patents and copyrights, have the characteristic that they don't expire at a particular time. Right? A patent and a copyright is an explicit bargain that says we will give you this right for a limited time, and then it enters the public domain. With both trademarks and trade secrets, our definition of the sort of extent and expiration of the right is functional. It's basically until it has stopped serving its purpose. And the idea, I think, in both of those cases is we want you to get protection for an indeterminate period, but we still want to tie that protection to whether or not the thing that you're protecting is serving its purpose in trade.
Well, it sounded to me from the article like, at least historically, this sort of durational conception of trademark and trade secret law was maybe a little bit closer, but that over time, and especially more recently, it seems to have diverged to some degree, or at least different principles seem to be driving courts' decisions as to whether a trademark or trade secret persists. I mean, I wonder if you could talk a little bit about sort of how that works in a trademark context and how it works differently in a trade secret context in relation to use or value, or what a claimant would have to show in order to make out a valid claim for continuing protection.
Mark, I'll take it unless you. Yeah. So Brian, you ask all the easy questions first. Yeah. So I mean, and I think, and I'm glad that Mark is here, because I almost forgot to mention the biggest point of the paper, which is that just like trademarks, trade secrets can expire even if they're kept completely secret and you meet all the other requirements, if you fail to derive value from them in the same way that trademarks can expire if you fail to use them. But you're exactly right that the way that these doctrines, it's all very fine to make this sort of elegant analogy between trademark abandonment due to non-use on one hand and trade secret expiration / abandonment due to failure to derive economic value. And in practice, we think there are a lot of really useful elements of trademark abandonment doctrine that could invigorate and clarify the trade secret abandonment that we propose via failure of independent economic value. But I do want to say that in practice, these do look very different. And in trademark law, we have this pretty crisp abandonment doctrine. I actually just taught abandonment in class, and there's this. Well, if the trademark owner has ceased to use the mark and lacks an intent to resume use in the reasonably foreseeable future, it's deemed abandoned. You don't really see that in the trade secret cases. Instead, courts are, in general, we argue that they're largely rubber stamping the requirement that a trade secret derive independent economic value. So if you look at the trade secret cases, they don't really resemble that. A couple senses in which they do. One is that if the trade secret owner is using the trade secret currently in the business, you don't really have an issue. And that seems to be sort of a one-to-one analogy to if you're using the trademark in all the proper ways, you're fine. But when we start to get to the point of where do your rights end, a lot of times the courts in the trade secret context will just presume that the trade secret always did derive, and is continuing to derive independent economic value from really circumstantial evidence, such as the fact that the owner has bothered to keep it secret, the fact that the defendant wants it, the fact that the plaintiff is willing to sue them in order to enforce it. And so you get sort of this cascade of presumptions that have in many ways gutted any kind of robust analysis of how trade secrets might be abandoned due to failure to derive value.
And so just to follow up on this, because I think we're now getting really to the sort of heart of our thesis, right? The way I would say it is this: both trade secret and trademark law have functional definitions for when does this secret end, when does this right end. Trademark law, as Camilla notes, has developed a pretty logical, coherent, well-applied set of doctrines for deciding when you are no longer making use of a trademark and therefore have abandoned it. Trade secret law hasn't. And in its place, what we've got is a bit of a hodgepodge, a lot of sort of weird presumptions, but also just a number of courts that don't really think about that issue in terms of abandoning trade secrets. Right? Courts think about whether or not the secret has been published and is no longer secret, but they don't think about the question, which strikes us as equally, if not more important, of whether or not the trade secret owner is in fact getting value from that secret in a way that the IP regime wants to encourage. And so drawing the analogy explicitly to abandonment, talking about this in abandonment terms, allows us to draw from the historical kinship between trademark and trade secret law, allows us, I think, to point to the ways trademark law has got it right in figuring out whether or not something's been abandoned. And so it allows us to think more crisply about when a trade secret might be abandoned.
So what kind of factors specifically do courts seem to be looking at to determine whether or not a trade secret continues to have economic value? And I guess the other question I have is, does it matter about who it has economic value for? I mean, could it be possible for a trade secret to be abandoned by its initial claimant, even though the secret might still have value for someone else?
Yeah, let me jump on in this one. I think the answer is yes, and that's really the key point that courts are not really identifying here. So if we just think of a secret as information that has value, actual or potential, then it's easy to say, well, you know what? Until no one could make use of it, this secret has value and therefore it belongs to the trade secret owner. And the extreme version of that, as Camilla notes, is cases that say things like, well, the defendant used the trade secret, so obviously it has value, case closed, right? Or the plaintiff sued and the plaintiff wouldn't have bothered to bring a lawsuit if this wasn't valuable to them, so clearly it has value, case closed. And we've gotten to the point where that sort of definition of value to the plaintiff has a circular aspect to it. But in fact, it seems to me worth asking the question, is this valuable? And the question, is the plaintiff actually deriving value from this, as separate questions because they don't always have the same answer. Now, Camilla mentioned the original restatement of torts, the idea that information must be used in one's business. That was probably too restrictive. One of the problems with that were cases in which an employee came up with an idea and rather than disclosing it to their employer, just took it with them and started a competing company. And the courts said, well, you never used it in your business, so it must not be your trade secret.
And you also potentially lost all of the prototype cases where the secret hadn't yet been commercialized.
Right, exactly. So I think what the more modern statutory framework does is say, you know what, this value can be actual or potential. It doesn't have to be current use in a business. But our point is that it does have to be something from which you are or planning to derive value. If you have left this on the shelf, if you've decided not to pursue the project, if you've gone in a completely different direction, it's not that the trade secret, that the information doesn't have any intrinsic value. It's that the plaintiff is not getting any value from keeping that information secret. And at that point, other people ought to be able to step in and make productive use of that information.
Well, so just to underscore the point, because it struck me as an important one. I mean, in the context of rights like patents and copyrights, even if the patent owner or copyright owner isn't doing anything with the work of authorship or invention or discovery in question, if somebody else wants to use it, the patent or copyright owner is still entitled to a claim, at the very least, a claim on the profits from the use of that work of authorship or invention or discovery. Why is trade secret law different? Why should it be different? I mean, why shouldn't the owner of a trade secret be entitled to a claim on the use of that secret information, even if they're not using it themselves?
So I think there's some really big reasons. One is that the trade secret owner hasn't been through the same kind of hopefully rigorous requirements of protectability that you see certainly in the patent context, right? We don't know whether they've invented something new and non-obvious. The second one is that the trade secret owner hasn't disclosed any information. And that's really important, right? Because the whole disclosure theory of patents is one of the big reasons that we're letting you have this sort of control right. And then the third is both patents and copyrights do eventually expire. They have term of years expirations. So we just think it actually, when you start to think about it, it's pretty odd and not really a good thing that we would give unlimited in times right to information when the person who's claiming that right hasn't necessarily contributed as much as we might want to society. And there's responses to that, like sort of the sharing, increased sharing ideas. So there are certainly responses, but as a general matter, I think those three things are pretty strong distinctions.
Let me note one other thing, because I think this is at the heart of most trade secret cases, and it's one of the reasons I think this matters. And that is that most of these cases come up in the context of an employer-employee relationship. And the combination of what we talked about earlier, the very broad definition of what information can count as a trade secret, including business plans, customer lists, and so forth. And even things like negative know-how, information about what didn't work. When you couple that with the sort of very broad definition of value that some courts are permitting, the practical effect is that a number of employees are hobbled in their ability to leave their job, start a new company, or leave their job and go to work for a competitor. Now, Camilla has written separately about the sort of limitations we try to put on trade secret law to make sure that you don't prevent someone from taking their general knowledge, skill, and experience. But I think it's also worth noting that because we've defined trade secrets so broadly, because they don't expire on any given date, and because they apply to people with whom you are in a business relationship or an employment relationship, we're putting a pretty significant limit on employee mobility if we don't have some point at which we say, you know what, this information that's sitting on a shelf shouldn't be used to prevent an employee from going off and starting their own company or going off and making productive use of their knowledge.
Mm-hmm. Yeah. I mean, so I wonder, are there broader social costs then associated with this? I guess it seems like a move to sort of presume economic value of secret information and effectively dispense with any kind of meaningful abandonment doctrine in a trade secret context. I mean, clearly that's bad for the employees who might want to use the secrets. Is it bad in a more general sense as well?
So just to add to the mobility point, I think the restriction on mobility this creates is really important. There's also, of course, the very fact that some of this information that's locked within the firm could be super, super valuable to society. And we want it to get out there, however it gets out, however it is. If there's something that society needs to know, and for whatever reason the company chose not to develop it, we want it to get out there. And then, Brian, your question is sort of, well, what about the countervailing considerations, right? And there are some really important ones. I mean, why do we have trade secrets in the first place, right? There's a couple of reasons to think about, but I guess some reasons we would want to let a company sort of claim an infinite duration of true trade secrets that are not general knowledge, skill, and experience, but true trade secrets as against their employees would be, I would say, number one, that they might not develop it in the first place, but that I don't really buy. Number two would be that they might develop it, but then, spend too much money to keep it secret. And then number three, that they and it's very closely related, that they would not share it with their employees. And the concern that you get from people like Judge Posner in the Rockwell decision is that there would be all kinds of inefficiencies introduced into the innovation process if companies didn't believe that they could share with their engineers and so forth when they needed to. And so you could see, I think you could have an argument that, hey, if we allow for trade secret abandonment, we're going to be introducing those kinds of frictions with employees. And, maybe just to use the case of the decade, Waymo versus Uber, right? If Waymo knows that if it shares with Anthony Lewandowski information about self-driving cars and then chooses not to develop self-driving cars, maybe it won't develop self-driving cars in the first place, or maybe it will, but it will be too afraid to share it with Lewandowski because maybe it doesn't necessarily trust him. And so you could have all those kinds of sort of ripple effects. I think that would be the main cost in the other direction.
Right. But what's notable about that is that those costs exist precisely in the circumstances where the company has actually got a theory of how it's going to derive value from this secret. Right. The most obvious case is I am using the secret and you take it to my competitor. But it's worth noting that our concept of abandonment has room for other kinds of use. One way you might use the secret is by selling a competing product. So if I come up with two pharmaceuticals that treat the same disease, I shouldn't have to develop both of them and take them both through FDA approval and testing. One way I might use the secret is by denying other companies information that would allow them to compete directly with me in the marketplace. And we think that's a legitimate use of a secret. Similarly, if I can license it to others who are making productive use of it, that too is permissible and valuable. So it's really circumstances, I think, where the company has just either gotten out of the line of business altogether or has just decided not to pursue a particular project, that information is going to sit on a shelf unless we declare it abandoned and allow other people to pick it up.
And the licensing point, and both points about sort of like deriving value from deliberately shelving or deriving value from licensing to others, exceptionally important. And people, I won't say that this happened, but maybe it happened, that people would read the first sentence of the article, get so angry they wouldn't read to the point of sort of, we allow for licensing, guys. And that is really an important caveat. We're not saying you have to use it or you don't have rights. We're saying you need to be deriving value from it, and that value can come from all sorts of ways. So so very important to keep that in mind.
Well, so if courts are doing it wrong now, what should they be doing instead? In other words, what should courts be looking to determine whether information that's still confidential has actual economic value for the company that owns it? And what should courts look to determine whether finding abandonment is appropriate on the kind of policy grounds that trade secret law is intended to promote?
So we go through all sorts of evidence that courts have looked at now, and we kind of show what we don't think is enough, right? We don't think just sort of referencing the possibility that somebody might want to license it in future. We don't think that's enough. But what is enough? So we're actually not too down on the idea of use. If the owner really is currently actively utilizing the trade secret in their business, you don't want courts to go and scrutinize that to make sure that it's good enough. And so there's a very low threshold. If you can show that it's more than minimal value and you're using it currently in the business, you're probably going to be okay. If you can show that you're currently licensing it, likewise, deriving value, we're not going to sort of go in and substantively assess how much value. So those would be some key things. I think the kind of scenario where we'd be drawing some really difficult lines are going to be where we have an employee departure and say, the employee was imagine the employee is herself the inventor of a technology. Maybe it is an Anthony Lewandowski scenario, and they've actually invented it. The employer says, we're not interested, but we might be, and there's sort of a gray area there. And then the employee leaves and goes and does it themselves. You can imagine some very difficult evidentiary questions that the court would have to ask there in terms of, well, were they deriving actual or potential value at the time that the employee took it? And by the way, that timing is important. They have to be deriving the value, independent economic value, at the point of the misappropriation. So in any case, here's where we think that courts could make this a more vigorous analysis if they took some lessons from trademark law. And in trademark law, you do ask, given a period of non-use, or in this situation, a period where there's no identifiable value being derived from the information, can the employer, can the plaintiff come back and show, yes, but we had an intent, a provable intent, to do something with it in the near future? And so that's where I think we do need to get a little bit more specific about what might be enough to show that intent. I don't know what Mark's thoughts on that point are.
Yeah, and I think, right. So what trademark law says, which we think is useful, is if you're using it, fine. If you're affirmatively licensing it out, you're using it, fine. If you're not doing any of those things, but you're making active preparations to use it, fine. If you're not doing any of that for a certain period of time, we're going to presume that you've actually abandoned it. And you've got to come back and prove to us that you actually have a plan. And I think adopting that framework a little more explicitly for trade secret law would do two things. The first it would do is give us some clarity and kind of rein in some of the cases that we mentioned earlier are all over the map and trying to decide what might satisfy economic value and have kind of loosened that requirement. But the other thing I think it would do is it would allow us to release from the vaults of companies information that really is just languishing, right? That people can't take for fear of trade secret theft claims, but which isn't really going to be used by anybody. I mean, some of the cases we talk about are cases where the information hasn't been used in a product in 40 or 50 years. Yeah. And yet when somebody goes ahead and uses it, there's a lawsuit filed. I do think there's a worry about opportunism. I'm not interested in making use of this information until someone else pops up and shows that it actually is valuable. And then I say, oh, that was mine all along. And I also think there's a value to employee inventors in having a backstop that says if you just devoted 3 years of your life at the company to working on this thing and the company says, yeah, you know what, we just changed our priorities and we've decided not to pursue it. You haven't just wasted 3 years of your life. You've at least got the possibility that maybe I could take my idea, if I believe in it, somewhere else and try to make it work.
Well, so this last idea I thought was really interesting, and I wonder if in closing you could reflect a little bit on why the move you're suggesting might be consistent with the policy goals of trade secret law specifically, and maybe of like innovation policy more generally.
Sure. So I think I think trade secret law has always tried to balance the interests of employers against the interests of employees, and these are the cases we struggle most with in trade secret law. It strikes me that the interest of the employer is at a low and the interest of the employee at a high. If the employee has invented something for their employer, the employer has decided not to make any use of it, not even licensing it out to others or getting a competitive advantage from making sure competitors don't have it. And the employee's interest in maybe taking it and running with it, if they believe in the idea, but they couldn't persuade their employer, strikes me as quite high. So that in turn, I think, drives innovation because it motivates employees. It may motivate them to work within the company because they know that their invention's not just going to be put on a shelf. It may motivate them to take ideas that are sitting on a shelf and go out and start a new company. And those are the kinds of things that if we think of trade secrets as an intellectual property right, we want trade secret law to be encouraging, not discouraging.
And I'll just add the one other, so that I echo that entirely. And I think, we're not just arguing that trade secrets can have value when they're returned to the market in the sense of the employee taking them and doing something new with them. There's also the public domain point, right? Because we're also talking about disclosure of information. It could be the case that the employee just wants to share things with the world, especially if it's things of historical importance. So I also think there's something to with the historical record to discuss here as well.
Well, Camilla, Mark, thanks so much for coming on the show. I really enjoyed this paper, and I hope that listeners will check it out because there's an awful lot more in there that we didn't quite get to in the interview.
Thanks very much.
Thank you. Thank you so much. Bye.
someone slipped and fell? Was that someone you may have longed for added strength, your courage to renew? Do not be disheartened, for we have hope for you. It is no secret what God can do. What He's done for others, He'll do for you. With arms wide open, He'll pardon you. It is no secret what God can do. There is no night, for in His light you'll never walk alone. Always feel at home wherever you may roam. There is no power can conquer you while God is on your side. Just take Him at His promise. Don't run away and hide. It is no secret what God can do.
For what He's done for others, He'll do for you too.
With arms wide open, He'll pardon you.